Different cultures also have different approaches, especially like in relation to harassment cases. What one would view as sexual harassment may not be necessarily viewed the same from a different perspective.
So we talk about these concepts, but what is harassment? Employees don't know. What is bullying?
Yeah.
What is discrimination?
Exactly.
So really being able to unpack that and train that's where the work culture comes into effect. If a company doesn't just have amazing policies, but really makes sure everyone understands what's in the policy.
Hello and welcome to today's episode of Workplace Investigations When Evidence is Elusive. We'll be discussing today the complexity of conducting workplace investigations across Africa and the Middle East. I'll be joined by two guests of mine. Thenji.
Hello, my name is Thenji Moyo. I am partner and head of employment at Gateley Middle East. I'm currently based in Dubai dealing with employment matters and workplace investigations.
And Sayi.
Hi, my name is Sayi Nindi and I'm a partner at Malatji Co Attorneys here in Sandton, Johannesburg, South Africa. And I head the Employment Law Department.
My name is Joyce Nkini-Iwisi. I'm a partner at HKA, taking care of investigations based in South Africa, but conducting investigations across the Europe, Africa, and Middle East region, specifically with expertise in workplace and misconduct cases. Thank you very much, ladies. And again, a warm welcome. Perhaps let's start with discussing why these cases are so difficult. Thenji, in the Middle East, on top of just the complexity of the technicalities around investigating these cases, there's social cultural norms that come into play, specifically for matters such as sexual harassment or reports of abuse of office, bullying, intimidation. What is your experience in how difficult these factors play into how you conduct these cases? What has been your experience and how have you tackled some of these challenges?
Thank you. The Middle East is quite interesting because what we have in Dubai is quite an interesting makeup when you look at organizations. So it's not unusual in an organization to have more than 20 nationalities. So people coming from different backgrounds. And once you have a melting pot of cultures, automatically there are going to be issues in the workplace. What might be good for one cultural group would be extremely offensive to another cultural group. So we tend to find that we have issues arising when it comes to just day-to-day interactions. When it comes to either defending such matters, we find that evidence is critical. Even in South Africa, a lot of these issues are sometimes quite challenging to prove because, as you know, misconduct is becoming more sophisticated, more complex, and more difficult to actually get the evidence that you need. That said, employees are also becoming a lot more aware of their rights. They are more able to generate a paper trail evidence. So we are also seeing cases where employees will make sure they have the right evidence. They will make sure that they have the WhatsApp messages. They will make sure that they've had a word with HR about bullying, harassment. They will make sure that they're able to build a picture. So managing these issues is really something that we always say as lawyers. Organizations should make sure staff are trained so that they're able to identify these issues early and preserve evidence. Some investigations are really spoiled because organizations simply don't know when to bring the experts like yourself in, or HR don't know how to deal with it, or actually completely ignore these issues. But yes, the UAE, because we're a melting pot, we find that if we're not undertaking training in the organizations, having discussions about what might be good for one culture is offensive to another culture. Sure. So these conversations are ongoing. But yes, we're having these issues still.
Yeah, and you've made a good point about when to bring the specialists in or the external investigators in. I would like your comments on this as well. I've seen cases where you are appointed, however, a mini or a pre-investigation has been conducted, and you find that there's a bit of a complexity that arises on the technical front with those cases, because you find that if a survivor for example, in a sexual harassment case, has been interviewed already, there's little to no appetite to speak about the traumatic experience that they've been through over and over again. What's your comment on that, and what are your observations when it comes to exactly when are external law firms or external investigation firms appointed?
I think it really should be done as soon as possible.
Mm.
In the Middle East, there is the added, if you like, complexity that some of these issues quite quickly also become criminal matters, right? So it's really important for management, HR, to identify when they need to bring in external experts in. My position is always as soon as possible, because organizations are better off bringing in the experts and the experts saying, actually, this is a matter that you can handle yourself. Some of the organizations that we deal with are regulated by the authorities. So, for example, the Dubai Financial Services Authority, the regulator themselves, will also want to be notified. So as a best practice mechanism, I always say as early as possible, as soon as issues are identified, to reach out to the subject matter experts to assist.
Thank you, Thenji. And just on the point of regulators, the Financial Conduct Authority in the UK is actually having in place from 1 of September this year regulation that speaks to non-financial misconduct, which is exactly the topic that we're discussing today. So we hope to see that trickle down across the globe, where regulators are actually focusing on not only financial misconduct, but non-financial misconduct across the board. Sayi, what do you see in South Africa? Social, culture norms, abuse of office. We recently had a very public hearing on the sexual harassment in South Africa. What are your views on this?
I guess South Africa is quite different compared to the UAE. We're not a melting pot as such. So you would not necessarily find different nationalities, but you would find different cultures.
Yeah.
So, and different cultures also have different approaches, especially like in relation to harassment cases. What one would view as sexual harassment may not be necessarily viewed the same from a different perspective. But in South Africa, I think we are progressing jurisdictionally in that we've got legislation, the Employment Equity Act, which now says that unfair discrimination is prohibited. And through this legislation, we also have a code that deals now with the prevention or the elimination of sexual harassment within the workplace. From the legislation's perspective, it is there, and it's now the obligation of the employer to start now implementing policies to make sure that employees are educated. As she mentioned, that you find that now, and I want to believe it's because of the legislation that is there, it's because of the codes, and it's because of the implemented policies that you find employees are aware of their rights. And so people will not necessarily get away with harassing fellow employees scot-free, and they will be called to answer for it. And as we have seen from the media, it matters not what your position is. So as a country, I think we're going in the right direction in trying to implement and to protect employees in their rights. Yeah.
No, I fully agree. And what's your view? Again, when you talk about the power dynamics in the workplace, someone so senior and perhaps someone junior, how do some of these reports come across? Do they come through whistleblower lines? What's your observation? Are they more through anonymous reporting? Are they direct reporting? And what's the role of psychological safety and how workplace culture contributes to how these reports come to light?
Yes. So there's a combination when it comes to the reporting of harassment cases. So the whistleblower line might help, but you'll find that most sexual harassment matters would come directly from the complainant alleging that there's a particular perpetrator or respondent that needs to come and answer for the allegations. In relation to workplace culture, I think this is where employee relations or human capital, HR, whatever you want to call it, they come in quite handy in that they need to educate the employees to know what the policy says, what is acceptable within the organization, and should the organization, for example, deal with the matter and the outcome is unacceptable or not satisfactory, that there are different avenues. But I think the workplace culture and what is acceptable or what is the norm within organization must be driven by HR, and the employees must know. So, for example, at this moment, mental health is also a very big thing within the workplace. So the wellness programs that the employer has, that is all driven and carried out by HR. So induction is good, but continual education of all employees within an organization is also very, very important.
Thenji, your views on exactly what is sufficient in terms of evidence would be super interesting. You know, internal investigations, we usually rely on a balance of probability threshold.
Yes.
Is that the same in the UAE? And what constitutes a balance of probabilities, specifically when you don't have hard evidence and it's a he said, she said, it's two people, no witnesses, no corroboration? How do you get to a balance of probabilities conclusion? Because at the end of the day, it has to be conclusive, one way or the other. Or in some cases, I've also had non-conclusive, right? Because there's just not enough information to get you there. But I think as experts, we always want to support our clients to get a conclusive finding. What's your view on that?
I think we need to also be really comfortable with saying there's just not enough evidence to go one way or the other. And it is really about balance of probabilities, as you've said, where we just don't have enough evidence. I mean, we will try and create as much of a picture as we can. Our witnesses are quite good when you ask them, is there anyone who can corroborate your position? Anyone who might have witnessed it, anyone that you might have spoken to. So we will ask probing questions to try and build a picture. What's also quite interesting, I think, is really trying to assess character and credibility, right? Look at appraisals. You know, how it's usually better when someone has been within an organization for a long time. Try and establish a picture. Have they ever complained before? I'm sure you've come across some situations where they're just some people who just complain all the time about everything. Right? Then you might have a situation where you find a very credible employee, never complained about anything, high performer, and then says something. And, you know, you can then build that picture. So I think as experts, speak to people, undertake an investigation, and try and establish character and credibility, because I think that goes a long way. And just on Sayi's point about, you know, trying to establish workplace culture, what we're finding increasingly in the Middle East is organizations undertaking pulse surveys, anonymous pulse surveys, where everyone is asked the question about bullying, harassment. And I was actually involved in an investigation whereby the CEO was terminated on the back of a survey that went to everybody, and certain themes came out, because if it's anonymous, employees talk about the management style and so forth, and it became apparent from an anonymous survey that there was an issue with the CEO and the way that he was bullying and harassing employees.
That's super interesting, because sometimes we tend to think these surveys are just sort of tick box exercises, but they have over the years proved to be very valuable tools, right? And I think the world we live in now, people are a bit more open to speak and to speak up. When we talk about gathering evidence, we hate retrospective scrutiny. We hate that, right? Like you get to the end of the case, look back and say, oh, I missed this, or I should have done this differently. What's in your toolbox for how to get it right? Thenji, on your side in the UAE?
Planning. I think planning, and sometimes we are pressurized by clients to say this investigation needs to be undertaken within a week. And I think that's the problem that you have sometimes as experts. I remember going into an investigation, and actually our intention was to interview everyone individually. And the instruction from the client was absolutely not. We're going to put the witnesses in groups. Now, sometimes you can understand when it comes to group, there's now a group dynamic.
Yes.
You want a situation where witnesses feel comfortable, feel confident that whatever they're sharing, it will be taken seriously, but also there'll be no retaliation.
Exactly.
So I would say planning your investigation, knowing who the witnesses are, planning your questions, even the order of the interviews, because you don't want a witness to influence another one, and trying to do it as quickly as possible to try and avoid any sort of issues when it comes to witnesses giving their evidence, making sure that any data that's collected has been processed carefully in accordance with the privacy regulations, making sure that whatever needs to be encrypted is encrypted, really just making sure that preservation notices are sent, so that once employees become aware that there's an investigation, there's no deletion of documents or laptops suddenly going missing and so forth. So it's really for us just about the planning. The more you plan and the more the client allows you to take the lead in how the investigation is going to run, I think it is better. But obviously when clients want results very quickly, you can sometimes feel that the integrity of the investigation might be compromised. So it's really important to make sure that you adhere to your standards.
No, absolutely. And the objectivity as well, right?
Absolutely.
Because you want, if you're outsourcing it out, I always advise my clients to just sort of allow us to drive the investigation, obviously with their input in terms of, what are the dynamics, who is who,
Of course.
we take their guidance on that, but it's always most important to have the independence and the objectivity intact, because we're external parties, we're coming in, we want to have an objective view. It might be that at the end of the investigation, you're saying there's no findings because of the, sort of the various conversations that you've had. And I think one of the issues that I've seen as well is perhaps getting into an investigation where there's already a pre-assumed outcome, and it becomes quite difficult. I see you both nodding. It seems like it's a general issue across. And so you're there to actually do the job of trying to be as independent and as objective. But you touched on a few points around technology side. I was going to come to that. So thank you for raising that, Thenji. Technology. I mean, there's almost no investigation I'm conducting to date that has no aspect of forensic technology. What's been your general observation of that? What's important also to take into account? What do you want to avoid in terms of retrospective scrutiny at the end of the day?
So when you talk about technology, I just think automatically of like the devices that might come in for purposes of collecting evidence. And that is where we as attorneys would require your services, where we call you guys to do the forensic analysis of the devices, the data collection, and all of that. So usually you'll find that the technology or the devices fill in all the evidentiary gaps that are there, or they corroborate the complainant, or sometimes even the respondent's case. So you are able then to get a fuller and better picture once you go in with your experts to take out the devices. But it's also very important in how all of this, of course, is conducted. The chain of custody must be kept, and it's very important because at the end of the day, you don't know where you're going to end up. If you're going to need to use this evidence, it needs to be admissible evidence. So you don't want to find yourself in a situation where the collection of the evidence has now compromised your case and your entire investigation. But I guess this is the situation where, particularly when it comes to dealing with devices, where we partner now with experts in that regard when it comes to imaging and all of that.
Yeah, no, absolutely. And I think we, as a standard, have the full suite of services. However, and Thenji, I think I would be very interested to hear from you. We find a massive challenge because across Africa, there's over 20 data privacy laws, right? And, if you compare that to the European market where you've got GDPR, which is, an applicable legislation that speaks to how you can manage data privacy. There's a massive complexity in Africa. What you can do in Kenya is not exactly what you can copy and paste doing in South Africa. It's not a copy and paste of what you can do in Nigeria. How do you plan for that? And how do you make sure that we avoid retrospective scrutiny? Because at the end of the day, you want a conclusive outcome. You want an outcome based on the evidence that you've gathered. However, if there's technicality failures, that all would not matter, because that is, that leads to your case being completely nullified. So how do you deal with that in your planning process? By the way, there's also times when the legislation even changes while you're conducting. I've had a case like that. I was conducting a matter in Kenya, and the legislation changed, it was updated during the time that we were delivering a matter. How do you deal with that and just make sure that you're completely aligned to what's required from a jurisdictional perspective?
I think these are really good points. The UAE is extremely strict. It has very strict laws on privacy. So, for example, you cannot record someone without their permission, express permission. You can't take photos. You can be imprisoned and fined. So, as a result, what we have is a very high standard, which we find meets international standards when it comes to making sure you have the correct processes and policies and permissions in place. So when we would, for example, just review organizational documents, we will make sure that it's compliant with, GDPR. They have a data privacy policy. Their employment contracts permit monitoring, permit processing data across jurisdictions. What you tend to find in the UAE is the head office, like Gateley Middle East, for example. Our head office is in the United Kingdom. So there automatically must be permissions when it comes to sharing our data with the head office, obviously for legitimate reasons, business reasons. So when we plan an investigation, we will look and hopefully make sure that those permissions are in place or try and obtain them. Otherwise, as you said, this evidence becomes inadmissible and that can completely nullify an investigation. So because we live in an environment that is very strict when it comes to privacy, and employees are aware of that, by the way. So you'll find, for example, a laptop, someone will have a company laptop, but they'll have a personal folder. And what that means is you cannot access as an employer. So when you do your forensics, even if it's a company laptop, if someone has a personal folder, that cannot be accessed, even if it's on the work trade tool. What we do encourage our clients is to make sure that they give the tools, make sure there is a company laptop, a company phone, a company SIM card. Some of the complexities arise when an employee says, well, this is my phone, but it's a company SIM card, and the bill is paid by the company. So what happens next? So those issues, we try and avoid them by encouraging that everything is issued by the organization so that they can own it, the laptop and do all the images that are required as part of the investigation.
Interesting, because I dealt with a matter previously in Nigeria where the employer had contributed a certain sum of money and the employee topped up the sum of money to buy a cell phone. The cell phone was part owned by the employer and part owned by the employee. We consulted counsel, and counsel said, no, absolutely, you can have access to that. It's considered a tool of trade because it's an allowance, cell phone allowance. The employer has contributed towards that. Now, in South Africa side, that would not happen, right? Because if there's part ownership by an employee, then absolutely not. However, we also took that position, even if we advise that, you can still look at it, just to err on the side of caution, because as an expert, the minute there's a certain level of contribution for me that I can see the employee has, and there's personal data on that cell phone, but mark you, this was a few years ago, so this could have changed in terms of legislation and what's being done currently in Nigeria. If there's some part of contribution by an employee, then absolutely not, would not touch that device, But I think these are just generally the complexities. And your examples, Thenji, on the personal folder, I dealt with a matter in Kenya. We had an employee having WhatsApp data on a work tool of trade. How does that sort of come into play? In South Africa, Sayi, I think if it's a work tool of trade, an employer has access to that device. But what can we or what can we not do, I think, is something that is a heavy consideration during the planning process, specifically when you plan to do forensic technology imaging, right?
In South Africa, we have what we call POPIA, POPIA, the Protection of Personal Information Act. And that is how an employer can go about accessing it. And it talks about the limitations and under what conditions an employer may access the employee's personal information. But talking about tools of trade, I was just listening to what Thenji was saying, I would just advise employers it's always safer to just own the devices. Yes, so that if in any circumstance you're required to take them in for investigation, you may do so because you have the right to do so. The tools of trade belong to you. So it's important that is specified as well in the contract. We recently had an investigation where the employment contract actually permitted the employer to have access to everything that is within the tools of trade, whether it would be a personal folder or whatever it is, as long as it is in the tool of trade, you are permitted to have access. And the person, if you're employed, you've signed the contract, therefore the employer would have that that access. In relation to taking in tools of trade and accessing information, it all just depends on what the employment contract says, what the policies actually also say. You may find that in a situation, for example, if you say that it's partly owned by the employee and the employer pays for the monthly subscription, but the policies might actually clarify that and say that in as much as you've contributed, just know that we still have the right to access it. So as I said, I'll go back again to the employer's policies are very important in a situation like this, so it can clarify any kind of confusion there may be.
And I guess periodic updating of the policies, right? Because once someone signs a contract, they might be employed at an organization for 20 years, right? And obviously things change during that time. So the periodic updating of the policies is super important because it clarifies what might have been missed when an employee was signing up.
Absolutely.
I would say updating is really important. If you look at where we are now, we've had the pandemic where people were remote working, for example, and now in the UAE we're also remote working on account of the situation in the Middle East. So you might find that the policies don't actually allow for remote working because you started 20 years ago. And what's the situation when it comes to accessing from abroad, VPNs and so forth? So really important to refresh. I always say even annually HR should be taking a look at their policies and see whether they're still fit for purpose, because organizations change.
Yeah, no, absolutely. Annually, and I think also periodically, because if legislation changes, for example, with data privacy regulations being updated, if that changes, it's critically important that the policy updates to reflect what's in legislation. So, for example, if an employee signed a contract to say, hey, the tool of trade in full containing whatever personal information there can be accessed by the employer, but POPIA changes and says, oh, actually you cannot access that. That's really important for updating, because I think then it can be argued by the employee that the employer is not in compliance with regulations, right?
And also training. Training, because many organizations have great policies, but we're not training our employees on the actual policy. So you find that some employees don't even know where the policy is. So, or you joined 20 years ago and it's on the intranet or it's with HR. So making sure, what I say to HR is, you can take a section of your handbook and say, we're going to focus on bullying and harassment.
Right.
What does bullying and harassment look like? And really have a workshop around that. In the UAE, the law changed 2-3 years ago and actually brought in bullying and harassment. So all of a sudden, under HR managers were more concerned about training staff and actually talking about what harassment looks like. So we talk about these concepts, but what is harassment? Employees don't know. What is bullying?
Yeah.
What is discrimination?
Exactly.
So really being able to unpack that and train that, that's where the work culture comes into effect. If a company doesn't just have amazing policies, but really makes sure everyone understands what's in the policy.
So Thenji, just on team setup.
Yes.
When we are conducting these investigations, and Sayi, I would be keen to hear from you as well. Team setup. What kind of team is the right team? And I'm speaking from a point of view of some of these sensitive investigations, like the sexual harassment ones, where perhaps a lady has come forward to report. Who do you have in the room with her as the external investigation team that holds her hand throughout the investigation process? For bullying and harassment, I've also seen cases where a gentleman is drawn to a point of vulnerability and needs to open up. Who do you have in the room to interview? There is a big portion of our work that requires a reasonable amount of empathy when you're dealing with these cases, because these are very personal cases. I often say, and by the way, my background's accounting, I often say as a forensic accountant, looking at numbers and dealing with numbers is not the same as looking at cases that have to deal with some emotive subjects. How do you compose your team? And is it on a case-by-case basis?
I think it should be on a case-by-case basis. I really feel that a diverse team is helpful, because sometimes when you're talking about sexual harassment, it goes without saying that sometimes women will feel more comfortable unpacking the sensitive issues to a female investigator. Language is also important, given that we are in Dubai, very diverse workforce. Making sure you have someone who can speak the language, I think, is a key factor, as we all know that sometimes it's easier for people to express themselves in their own language for you to fully understand the issues that are at play. So I would say language, sometimes age as well, when you're looking at that. So gender, age, background is all really important when it comes to making sure that you're able to fully access what the individual is about. But obviously the technical experience goes without saying, making sure that you're adhering to the legislation when you're actually getting the data and so forth. And not, for example, investigators need to know that they shouldn't lead. When you're asking questions, leading questions, open questions, allow whoever's being interviewed the opportunity to fully express themselves, so that what has been relayed can be investigated. I would say when it comes to team makeup, I would say that would be critical.
Sayi, what's your view on just sort of how you manage the investigation process, how you manage expectations of whoever you're engaging with, be it the subject, be it the complainant, be it other interviewers? Documentation, of course, is key. But what's your view on something sensitive like recording interviews? How do you record? Do you take notes? Do you have a device to record? It's a topic of contention, but what's your go-to and what do you advise?
I would actually I agree fully with what Thenji has just said. And just to add on, what I found is that when we're doing sexual harassment investigations, it's also very important to make sure that the complainant is comfortable. Over and above what Thenji has said, we were investigating a matter where the lady actually chose to come in with her husband. So whatever companion the complainant feels comfortable with to relay the story, that should also be, welcomed. I mean, it goes without saying, I guess. Yeah. With me, when it comes to conducting investigations, before the interview starts, you just inform them that here we are doing information gathering at the moment, and we require that all the information that we get from you is recorded so that we don't miss anything. Because sometimes when you rely on your handwritten notes, and you've seen when a person speaks very fast, your scribbles sometimes are illegible and you can't really, make out. Then you have to sit with your colleague and say, what is it that she said, So it becomes so difficult. So I say the safest route is always to try and make sure that whoever you are interviewing for purposes of the investigation, it is recorded. And what we do, usually you have the set of questions that we ask. And if it's a big investigation with really one big allegation, you try to have similar questions so you see how different the responses are, so that you can see where the loophole may be.
Thenji, do you record interviews in the UAE? I know jurisdiction to jurisdiction, it varies. Do you record?
Yes, we do. As long as we get very similar, as long as we get consent, we will record. Now sometimes it's on Teams, sometimes it's in person. So we would start off by explaining that this interview will be recorded. Do they give their consent? And as long as we have that, then we would record. We would proceed with that. And it's helpful to be able to scrutinize what was said.
Yeah.
What we also usually do is that at the end of each person that we interview, and sometimes depending on how big the investigation is, we try to convert each interview into a statement. So capturing exactly what was said. So you'll find at the end of the investigation report includes a number of statements from the people that we interviewed.
And then I think just in relation to that point, I found that the sexual harassment cases are quite difficult to record because of A, how emotive they can be, but B, because you want to give a deep level of comfort and trust, and which is a key factor in investigations, especially if it's a survivor-centric approach that you're deploying. The level of training as well for the team that's going to be deployed. A few years ago, we made a decision to have anyone that's dealing with sexual harassment get trained in Geneva. There's a really great training institution there, just so that we were comfortable that whoever is engaging in having interviews with survivors or, potential victims of sexual harassment is well trained in how they manage those interviews. But I would say it varies. I found, in Europe, less recording, much more taking notes. Here in Africa, the norm, we try to record as much as possible for exactly the reasons that you've mentioned, Sayi and Thenji, which is actually the best case scenario. You'd get to do that. But there's also times an interviewee will say, I want to speak off the record, for example, to say, hey, I want to open up, but this must be off the record. Again, talking about credibility, you assessing the information that's being reported. I think that has been a really productive chat. Thenji, a few last nuggets from you, Sayi, as well, and then we'll wrap up this conversation.
I think the key takeaways from my end is really taking action early, bringing in the experts early, making sure you follow the correct processing for data collection. We spoke about policies, training. I would say those are really the key takeaways in terms of ensuring and maintaining the integrity of workplace investigations, which are sensitive, and not forgetting that the failure to do so can impact the brand. Corporate reputation is key now. We're living in a time of social media, and it just takes a negative a story to negatively impact organizations. So I think now organizations really should be taking any grievances or complaints seriously.
Yeah. Sayi?
Yes, I couldn't agree with Thenji more. As you're saying, the training and the education of the employees is very, very important on what is acceptable and not acceptable within the workplace. As you had mentioned that you find somebody who's been there for 20 years. I've interviewed plenty of people. And then you ask them, so what is the policy in relation to 1, 2, 3? and they really have no idea. And they just say that this is what I've just been doing. And then if you tell them, but your policy says otherwise, and that surprises them. So they mustn't just take for granted that everybody knows what is required and expected of them in terms of legislation, in terms of policy, in terms of their contracts. So the HR training is important. And once that training is has been conducted, ensure that they sign for it. So you've got proof that on such and such a date, even if they didn't come, they were invited and they chose not to come. But this training happened. The staff has been educated on this particular issue.
No, thank you both very much. And I think just to wrap up, the final point would have been something you mentioned very early in the process, Sayi, about how these reports come to us, whistleblowers, ensuring that we have lines, communication lines that people within organizations feel comfortable to report, whether openly or anonymously, and then the hard work then falls onto us to be able to decipher what's been reported and to get to an outcome, and hopefully not an inconclusive one.
Yes.
Hopefully.
Yes.
No, thank you both.
Thank you so much.
Thank you to our listeners today. We hope you found this discussion very insightful. We hope to have you listening in on the next episode. From us today, it's a goodbye and thank you again.